Of you, dear legal ethics students. I think tomorrow I have got some examination. Anyway, let us complete the question paper 2021 as early as possible. So, let us quickly go to the questions part. Question number 15. X, an advocate, was suspended from practice for 1 month. Why? On the ground that he put upon unusually big name plate with multicolors. Not only the big hoarding, that with multicolors. That too with radium stickers also. So night time also it will be visible. And also he mentioned that on the nameplate that he was the former chairman of the State Bar Council. Okay, right. So now this was challenged by Mr. X. So, Chairman, Bar Council, okay. It was challenged by Mr. X that it is against to the legal ethics. Yes, 100%. So, first of all, you have to remember Rule 36. Rule 36, you know that an advocate should not publicize. This advocate should not solicit work. The advocate should not use touts to get work. Okay? So, Kabati, it is against to the principles. Rule number 36. So, in this connection, you have to remember this is a straight case law which was dealt with by the Bar Council of Tamil Nadu and Puducherry. So, this case is otherwise popular as Muthu Malar case. You can note this case as M. Nelson versus Muthu Malar 2018. Already we have discussed this case at length. So here what happened is basically it is against to Rule 36. Rule 36 clearly says that the advocate should not advertise, should not use touts, should not solicit the work. Right. What happened in this case is Mrs. Muthumalar, she studied law from Sri Krishna Devaraya College in Andhra Pradesh. She is a native of some in Tamil Nadu state. Right. While pursuing her studies, she worked as a teacher, as a yoga teacher in 2 schools in Tamil Nadu. One is a private school and another is a Jilla Parishad or government school. She completed law, then she tried to do the post-graduation course also. Of course, she could not complete the post-graduation. LLM, she could not complete. She is an LLB. And inspired by her as a husband, so he also took admission for the first year in LLB. Of course, he could not find time to go to the college, so he was not issued with a degree. Ultimately, they have erected a very big hoarding in Trinelveli or their area. So, stating that they are experts in family matters, they are experts in family counseling, they are experts in commercial like arbitration. So many things they have written. So, of course, people they are not much bothered. But the bubble was broken when their own brother-in-law, Mr. Nelson, filed a case against them. Actually, that is also civil case. There are civil disputes between the husband of Muthumalar and Nelson. And Nelson thought that these people using their position of advocates, they are doing some mischief, and therefore he went to the civil court and got an injunction order regarding particular land. Even then, as a sort of precaution, he obstructed the roadway. Injection order teskunar ayina sare veelu vastarani cheppi atanu chilla kampa, he has put it as an obstruction, admitted. But this woman and her husband, both of them went there and they set fire to the so-called chilla kampa ki taalam pettaru. Then they went to the Nelson went to the police, he reported the matter, a case of 447 IPC was registered, and ultimately he put a petition to the Bar Council of Tamil Nadu and Puducherry stating that this woman has not completed that is a PG course, and she studied while working as a teacher. All these things have come out. Then the disciplinary committee. So a very famous advocate, he was appointed as the disciplinary committee boss, and he has inquired totally. And in this connection, the government school where she has taken honorarium, వారానికి 2 రోజులు పనిచేసేది, డబ్బులు తీసుకుని సంతకాలు పెట్టింది. So she was caught. Then the country stated Madam, how can you put one leg in Tamil Nadu and the other leg in Andhra? And the principal was also taken to task. Even though she did not study, has given some attendance, all these things. There's a different topic. So this is the problem. So ultimately, both of them were removed from the roles of the advocates. This is what is called. But nowadays, please remember, if you go to just dial, your name is there. Is it not? Then how it happens? So please remember, there is an amendment. So in the case of, I think V.B. Joshi, yeah. V.B. Joshi versus Union of India, 2008. Yes, V.B. Joshi said, yeah, when they technically we were advancing so much time, why don't you give our name? What is this restriction? You restrict that Rule 36 says that number plate should be like this, name plate should be like this, you should not propagate, you should not give interviews, all these things. What is this? So, since we are technically advancing, luckily the Bar Council of India has given a leverage that you can mention your name, your registration number, your cell phone number, your expertise, your qualification in the website and not more than that. Anyway, it is an exception to Rule 36. Very good judgment. So these judgments if you are able to write, definitely it will be useful. So you have to say that the advocate should not advertise, the advocate should not propagate, should not establish so-called big billboards. Right. Now we'll go to the next question. A. An advocate failed to attend on a particular date of hearing in the court. Right. On behalf of the client. So client complained the same. On a complaint by the client to the State Bar Council, advocate was suspended from practice for 1 year or so. For 1 year. X challenged the act of the State Bar Council. So decide. What are you going to tell? So please remember, even though you are in the final year, better you write a positive answer. So definitely, what is this rule? I think Rule 11. Rule 11 says you have to take up the case whenever a client comes and the court in which the case must be the court in which you are practicing. మీరు సివిల్ అయితే సివిల్, క్రిమినల్ అయితే క్రిమినల్ ప్రాక్టీస్ చేస్తుంటే ఎవరైనా క్లయింట్ వచ్చి కేసు అడిగితే డెఫినెట్లీ యూ హావ్ టు టేక్ అప్ ది కేస్. Rule 11. Having taken up the case, it is your bond and duty. Ethically you are bound, morally you are bound to attend the court on all possible dates of hearing. Right? Is it possible for an advocate? An advocate may have 20 cases on hand. Can he spread all his hands? No, so he has only 2 hands. So in that case, the court is also considerate. They say that you can send your proxy. అంటే మీ యొక్క జూనియర్ని, మీ యొక్క డూప్ని పంపవచ్చును. Who will intimate the court that you are busy with another court work and that you will attend on the particular date or post it to some other date. Even otherwise also, even though you do not go, the magistrate will give consideration. He will post the case, he will keep the case aside, he will wait up to 4 or 4:30 p.m. Then only he will give the judgment, give the adjournment, or he may ask you to pay some costs or other things. But anyway, the basic duty as an advocate, whenever you file wakalat under Order 3 Rule 4, it is your bounden duty to attend the court. So not attending the court on the dates of hearing and also not attending the court with a reasonable explanation, definitely it's a violation of Rule 11 of the BCI rules. So definitely, according to Section 35 of the Advocates Act 1961, yes, an inquiry can be conducted. Bar Council of the state, they can take disciplinary action by instituting a disciplinary committee. The committee will be containing of a senior advocate plus 2 advocates, and the procedure adopted by them is according to CPC. What is the procedure of CPC? You all know well. So taking evidence on oath, taking evidence on affidavit, then asking for the documents, requesting for the documents, production of documents, investigation, inspection of documents, appointment to the commissions, all these things you know very well. So this is the procedure they will follow. So they will follow the principles of natural justice also. So after all these things are over, then only they will give the punishment. So Section 35 gives enormous powers to the Bar Council. Yes, the punishments are like suspension. So for 1 year, of course, it may be disproportionate. If he continuously absents for the adjournments, so Taking adjournments is a hobby or it has become a habit for some of the advocates. It amounts to, please remember, misconduct as well as contempt of the court also. What is criminal contempt? Disruption or the non-cooperation with the procedures of the court. If you don't cooperate, definitely, please remember, it amounts to contempt. Okay, let us not bother about that contempt. So asking for frequent adjournments is itself amounting to misconduct. So case law, S.J. Chowdhury versus State, 1984. S.J. Chowdhury versus State of West Bengal, 1984. Here, the advocate, for something or other, for some reason or other, always is asking for adjournments. It is taken on the dates of hearing. So normally you may be knowing, according to section 309 CRPC, normally the procedure of the trial should go on continuously, and if necessary, the court can give adjournments. How many? Only 3. But it should not become a habit for you. If it becomes a habit, it amounts to misconduct. Second case, Parikshit Sai and others, Parikshit Sai and another versus Indra Bhoi Ram, 1967. Well, anyway, you know, not attending the court on the dates of adjournment without sufficient reason. It amounts to misconduct and violation of Rule 11. This much is sufficient. Then we will switch on to question number 17. What does 17 say? Question number 17. A judge was a relative of the advocate. So judge and advocate, both of them are relatives. Okay. The advocate, so the matter came before the judge. The matter filed by the advocate. ఏం తెలియదు జడ్జి అని తెలియదు, మొత్తానికి ఈయన వేసిన కేసు జడ్జి గారి ముందుకే వచ్చింది. On a complaint by the client to the State Bar Council, advocate was suspended from practice for 1 year. He challenged the same. So yes, definitely. Please remember, right here, Rule 6, to some extent Rule 6, you should not argue the case where you are likely to be a witness or where your known persons are involved or where relatives are involved. Here, the judge is related to you. So, even the principles of natural justice do not agree. They say that better you keep aloof. That's why we have to remember Blackstone's legal concept. Justice should not only be done but should appear to have been done. That's why the judges will be recusing from some cases. మా చుట్టాలండి ఎప్పుడో నేను లాయర్గా పనిచేసాను పక్కగా తప్పుకుంటారు కాబట్టి you should not appear before a judge who is a relative. That I think husband and wife case అయితే మీకు చెప్పినట్టు గుర్తున్నాను, నాకు గుర్తుంది. బట్ there is another case, please remember. ఇదే కేసు సత్యనారాయణ సింగ్ and others versus Ramnath Singh others. Wife and judge. Wife is a judge and husband is an advocate. So the matter came before the wife and he wanted to argue. Somebody sent petitions, it was stalled. It's very simple. You all know, whenever your relative is there, you should not argue on behalf. Why? What is the reason behind it? You must be able to know. The reason is that you will exert some influence over the court. Ayya, ma tamudu sir, ma bhavamar sir, ani meer court batiladukuntaru. And you influence. So for that, to avoid that, please remember, you should not argue. You should not appear in a case where your relatives are figuring as accused. So a doubt may come. Can I self-appear in my case? 100% accepted. What does section 32 say? Section 32 says, not only the advocate said, not only the advocate, any person, if allowed by the court, he can represent the matter. So definitely you can argue your case but not your relative's case. This is the reply. Then we will go to question number 18. ఏంటది? Advocate running departmental stores. ఒకసారి చూద్దాం కేసు. Ex an advocate was doing the business of running a huge departmental store. So this advocate is running a huge departmental stores as a sole owner in the city. Okay, he has got a department store and he is running the same, and there is no other. He is not a sleeping partner, he is the sole proprietor. So when this fact was brought to the notice of the State Bar Council by a co-advocate, so co-advocate ఖాళీగా ఉండి ఈయన పిటిషన్ పెట్టి ఉన్నట్టున్నాడు, మనోడి పని చేస్తున్నాడని చెప్పి, then State Bar Council suspended X for 1 year from the practice, from the 1 year from practice. X challenges the act of the State Bar Council as unconstitutional. Decide. If you are a judge, if you are a member of the Bar Council, then what are you going to say? Yes, it is 100% correct. ఏంటిది? నో డౌట్. మరి మాకు ఎప్పుడో పాతకాలం నుంచి బిజినెస్ ఉంది, మేము చేయొచ్చా లేదా? సో గో అండ్ రిఫర్ రూల్ 47. ప్లీజ్ రిమెంబర్, the advocate shall not personally engage in any business. He should look after his family business, but he should not personally engage in any business. This is the most important thing. You can be a sleeping partner allowed, but you cannot run the, because what is legal profession? Legal profession is 24/7. You must always concentrate law. You must study law. You must be well versed with the legal provisions. You must suppose, for example, from tomorrow onwards, the amendments which were passed in case of Motor Vehicles Act 1988, they are coming into force. So, in which section 166 clause 3 of the MV Act, what does it say? It says that the period of limitation is only 6 months. Previously, it was unlimited. So, if you do not know this provision, what happens? You are under the impression that you are doing business. So, you might have studied 1 year back. You may be under the impression that you can file the case at any point of time. But law has changed. These changes, retrospective rulings, overrulings, judgments, deleted judgments, so many will be there. Unless you are thorough with all these things, it is very difficult for you. Therefore, you must concentrate only on law. But of course, you have got family business. You can do it, provided it should not obstruct your profession. Right? Here, what is happening? Please understand. Here, he is running a departmental store. To get more clarification, in the question it is given, he is the only sole owner, sole proprietor. That means there is no other person to look after this business. He is doing business. Just like in that Sai Baba case, advocate, what happened? He has taken a PCO, public call office, for rent since he was a physically handicapped person. After getting enrollment, he has transferred. Of course, he has got it run by his wife. But when the petition came, he has withdrawn from the running of that business. So likewise, please remember, definitely advocate is not supposed to do business. Maybe a family business, totally he should not concentrate. He should totally concentrate on what? On the advocacy, on the legal profession. Right? So there are case laws. So one case is Pavan Kumar Sharma. Pavan Kumar Sharma versus Gurdayal Singh, 1998. Pavan Kumar Sharma versus Gurdayal Singh, 1998. So here the advocate Pavan Kumar Sharma, he is running taxi business. That means he has got 4 cars. He is running them. He is maintaining it through some drivers. Of course, he is not driving, but he is maintaining. So it's a business. It's a contractual work. Travels. Board లేకపోయినా జరిగేదే కదా. Definitely it's a business. So అందరూ మామూలుగా మిగతా లాయర్స్ మాకు కొంచెం తక్కువ రేటుకి వస్తే ఏం పట్టించుకోరు. ఇతనేదైనా దానికి ఎక్కువ రేట్ అన్నాడు అనుకోండి, డెఫినెట్లీ దే విల్ కంప్లైన్. వాట్ ఎవర్ ఇట్ ఈస్, ద మ్యాటర్ వాజ్ కంప్లైండ్ టు ది బార్ కౌన్సిల్. When the matter is complained to the bar council, definitely according to section 35 the advocates, they are the competent person. They should conduct the so-called inquiry. They have conducted the inquiry. These people attended. They deposed evidence, and it is proved that he is running business. So therefore, he was suspended for 1 year. Right. Now, when the matter came to the Supreme Court held that he is doing the business on leisure time. In leisure time, he is not continuously running the taxis. Of course, he is managing the business. He is not doing the business. Managing the business is different from doing the business. So, even though he is the sole owner for the 4 cars, he is getting the work done through some acting drivers. So therefore, the suspension was lifted. Negative example. Sai's case is the positive example. So with this, I think we have completed 2021. Thank you very much. So we have completed almost important question papers. So if any doubts are there, you can contact me in your comment section. So for this semester, I think we have completed the syllabus. Of course, I think you are going to write the final exams also. Some date, 16/4 or some date has been given. Anyway, so good luck to all of you. So prepare well and attend for the examination, definitely. Even though you do not know the case law, you can write in a decided case law. Like that you write, definitely you will come out with flying covers. All the best for all of you. Thank you very much. I am closing the video session. Thank you.